All right, well, welcome everybody. I'm Nate Garhart from Farella, Braun and Martel in San Francisco and in St. Helena. And I'm here today to talk about IP and privacy protection for the wine industry. Most of IP and privacy protection really is going to be similar across most industries. There aren't too many unique issues, but there are a couple of things that are unique about the wine industry, and we'll touch on those as we go. So what are we going to talk about today? We're going to talk about, as promised, IP and privacy. So what are the IP issues? A lot of issues with trademark, copyright, and trade secrets we'll talk about. We won't talk about patent. I'll talk about the difference between these areas, but the bottom line is that patent requires a certain level of scientific expertise. And so, frankly, most people that practice in trademark, copyright kind of IP don't practice in the patent area. You need to go to a patent specialist for that. And we'll talk about what patent is, what it covers, and when you might need somebody for patent help. We'll also talk about agreements and how IP plays out in agreements, as well as online policies, which are just agreements. So we'll talk about terms of use. We'll talk about privacy policies, and that will get us into the privacy discussion. So let's jump in. So first of all, what are the types of intellectual property? Well, I mentioned trademark, copyright, patent, and we'll talk about trade secret a little later. But the three key areas are trademark, copyright, and patent. What's trademark? Trademark is part of the brand, and we'll talk about the brand versus a trademark. But trademark identifies the source of goods or services. It's words, logos, sounds, colors, even smells can work as trademarks that identify source. And we'll talk a little bit more specifically about those, but just generally, trademarks identify source. Just remember that part. Copyright protects original works of authorship. So your books, your music, your plays, photographs, software, all of that is protected by copyright. And we'll talk about the interaction or the differences between trademark and copyright. Then patent protects inventions. And that's, again, in order to work in the patent sphere, you need to have this scientific background. And so you can imagine, I don't know if you've ever seen a patent application, but they are otherworldly in some senses. They are definitely the engineers of the world out there doing that kind of work versus, for lack of a better term, the creative side that tends to be in the trademark and copyright area. So brands and trademarks. What's the difference between a brand and a trademark? What you see on the screen are a couple of very famous trademarks. Apple's logo and Nike's wordmark Nike, along with the Nike swoosh. The difference between the brand and a trademark is a brand really embodies the entire philosophy, the ethos of a company. And it's how you communicate to your consumers what your company stands for, what your product stands for, the nature and quality of your goods and services. And that can be encapsulated over time into an individual trademark. So when you see the Nike mark, for example, you know their shoes, but I'm sure all of us have certain attachments that we have or understandings that we have concerning Nike and what it means. So to me, it means striving. To me, it means athletic success. And so that's the kind of message that Nike has communicated through its various marketing and advertising programs, so that now when I see the trademark itself, that entire brand philosophy comes through. Same thing with Apple. When you think of Apple, you think of, well, one of their campaigns, Think Different. They did things differently. You think of keep it simple, easy to use, high quality. Lots of those kind of aspects are all tied up into the brand. And then that brand is encapsulated by a mark, a trademark that's associated with all of that message that they have provided over years of marketing and advertising and through their products and services. So here are just a few of my favorite trademarks. I like the FedEx mark because if you notice, the E and the X form an arrow. That was very purposeful by them. I didn't notice that for a long time, but I think it's really brilliant. I won't go through all of these, but one of the others is, you see the Pink Panther there. I don't know how many of you have shopped for housing insulation, but Dow Corning They offer housing insulation, and it is the color pink. It's that fluffy fiberglass insulation. If it is pink, it is theirs. They own the color pink in connection with housing insulation products. And so you won't see another product in that area that is pink because Dow would take action against them for infringement of their trademark. Just really quickly, Ambien, I really like because it's good morning. You might not think of it, but it's a sleep aid, and so it's a sleep aid so that you have a good morning. And then finally, I like the BMW grills that you see on the front of all BMWs. And the reason I like it is because they have had that since their first car. They've changed over the years. They changed in shape a little bit. They started out much higher and longer, and they've, evolved over the years, but they remain a key part of their brand. They evolved, but didn't drop that brand ever since they built their first car. So it's really amazing. Last thing I'll point out is in the Amazon mark, it was originally designed to say that it's a smile from A to Z, because they offer everything from A to Z.
Oh, wow.
So not only can you register words or colors, you can also register and protect what's called trade dress. And what that is it's the way here it's a building. I think we've all been to a Noah's Bagels and could recognize that as pretty much the layout of a Noah's Bagel shop. You can do it, for example, how your wine label lays out, certain aspects of your wine label. Now, a couple of keys are, first of all, that it has to be original. So one of the things we do see in wine labels a lot is there is a lot of, imitation is the sincerest form of flattery, and there is a lot of similarity between certain groups of wine labels. So it's not uncommon for wine labels to share certain aspects of how the label looks. And so if that's the case, any one of those users of that kind of layout is not going to be able to protect that, because it has to identify your label, one source, not many sources. And so in that case, you're not going to be able to protect that trade dress because it's not original enough. The second thing is you have to prove secondary meaning. You have to prove that consumers will recognize it, basically, because if you've used it for a certain period of time. Basically, you get kind of, they give you the benefit of the doubt if you've been using it for 5 years or more. But even if you've been using it less or more, you can point to things like look for advertising, or showing that it's part of the layout of your trade dress is part of your overall marketing campaign and advertising campaign. So trade dress is very protectable, but it takes a little more than your average trademark in order to get that protection. So what about trademarks? When I'm choosing a name, what do I have to think about? One of the first things you need to think about is trademark strength. Stronger marks are more protectable. The strongest marks are those that are the most distinctive, and it's measured on a scale, and the scale starts with fanciful marks, that is made up words. The classic fanciful mark is Xerox. Never meant anything, has no meaning in any language, is not somebody's name, was just a made up word. Kodak was another one. But they make up these words and they're very protectable exactly because they're fanciful and have no meaning. The next strongest category is arbitrary words. So words that have meaning but don't really have any meaning in connection with the goods or services for which you're offering them. So yellowtail is a classic example of that, in that, yes, yellow and tail are both words. There are things, animals, I believe, that are known as yellowtails, but they don't have anything to do with the wine itself. Next down is suggestive, and this is kind of the sweet spot because there's always a pull between marketing and legal about trademarks, in the sense that marketing wants the trademark to talk about the product, to tell you something about the product, and legal says, well, it's not going to be as protectable. And so the sweet spot are suggestive marks. So they're marks that don't necessarily identify the nature or quality of the goods or services, but tell you something about it, give you some sense about it. So toasted head, for example, I immediately get connotations, especially if it were in connection with, say, a Chardonnay or something like that. I would immediately get some sense of what it might be about. And as I get to know the wine, that will be reinforced stronger and stronger to the extent it accurately does suggest the nature or quality of the wine. So those are really where it's best to land, the most protectable and the most effective at the same time, kind of a balance between those two. The next level down in protectability is descriptive marks. That doesn't mean that you can't protect them. It just means it's harder. So a couple examples of those are, first of all, Mondavi's there because it's a last name. And this is very common in the wine industry to use somebody's last name as the name of your wine. Last names, surnames are not protectable unless, kind of like trade dress, you show that you have secondary meaning, that you have acquired, that the mark has acquired distinctiveness through your use of the mark and keeping others from using the mark. So if you do name your wine after an important person in the winery, and you only use their last name, you will come up against that and need to show that secondary meaning. Napa Valley, you would think that would be very hard to register, and we'll talk about AVAs in a little bit, but Napa Valley is actually registered by a trade group here in Napa Valley that makes sure that people are only using it in connection with A, wine, B, in connection with wines from the Napa Valley, and that it's used appropriately. And then finally are generic terms. Classic would be Merlot, or any other varietal would be a generic term that you could not protect. And the reason Thermos is up here is because there are terms that were once protectable and even registered trademarks that are no longer protectable, and Thermos is one of those. Thermos was a registered trademark for use with insulated water bottles, basically, and coolers, and they lost it because everybody started referring to any insulated water bottle or cooler as a thermos. And once that becomes the case and it no longer identifies the source, but instead a group or a type of product, it becomes generic and it's no longer protectable. So there are lots of those in the world that you're very familiar with. Aspirin was a trademark. It was owned by the Bayer Corporation, and they didn't enforce it, and others started calling their acetylsalicylic acid, they started calling it aspirin. And at some point, it stopped identifying Bayer aspirin and became just a pain reliever, acetylsalicylic acid, and anybody could use it. You'll notice that that's in the US. In Canada, if you buy aspirin, it is Bayer aspirin. In Europe, I don't even know if you can get it in Europe, but if you get it, it will be Bayer's product if it is labeled as aspirin. Escalator was another one, yo-yo. I could go on and on. There are a lot of these out there. And what's the point of that? The point of that is you do have to be careful. You do have to enforce your rights. If you do want to protect your trademark and keep others from using it, you can't just register it and say, I'm done. You have to keep an eye on what's out there, who's using it, or even using similar marks to make sure that you keep your rights strong. So let's talk about AVAs really quickly. I mentioned Napa Valley, which is an AVA. Those are registered with the TTB, and there are 275 of them nationwide. Not surprisingly, most of them are in California. The interesting thing about them is, well, a couple of things. First of all, there are very clear boundaries. You're either in Napa or you're not in Napa. There's no question to, well, I'm close to Napa, doesn't that work? For an AVA, no, you're either in or you're not in. In order to use that identification, you have to be in the AVA. The second thing is, unlike a trademark that's descriptive, in order to use the AVA, in order to get protection from the AVA, there's no need to prove consumers' understanding. It's just a given. And you can't lose protection of the AVA through unauthorized use. So while there are groups that would definitely take action against somebody outside of Napa Valley using that AVA, the fact that if it's not enforced does not mean that the AVA will suddenly go away. And the key limitation is for AVAs, it's only protecting against use on viticultural related products. So if somebody makes well, I won't use that. If somebody makes a line of furniture and they call it Napa Valley, the AVA, and they're located in Texas, the AVA will not give any protection to keep them from doing that. it would only be a wine product. A wine product from Texas labeled Napa Valley would be immediately actionable for a violation of the AVA limitations. So choosing names, when you go out and pick a name, one of the key parts of it is understanding that you need to make sure that there aren't marks out there that are already similar, so that if you use the name, you would actually be infringing somebody else's rights. So in order to determine that, there is a long list of factors that you look at, but the bottom line is the important factors are how similar the marks are and how similar are the goods. And so when a client comes to me and says, hey, we're interested in using this trademark, the first thing I do is undertake some searching to see what else is out there and what level of risk is associated with moving forward with that mark. I've got a slide out of order. I'm going to come back to that. So there's two kinds of searching that I do. The first is preliminary searching. That's largely looking at trademark databases. Usually the USPTO database, because that's where most of the clients I'm working with at least initially want to sell their products. But to the extent they want to sell in other countries, we start looking at other trademark registration databases around the world. And we see what's out there and what level of risk is associated. I keep saying level of risk because I hear a lot of people use the term trademark clearance. You really can't clear a trademark. You'll never know for a fact that there's no risk out there. But what we try to do is try to get educated on the level of risk so that we understand whether it's a risk that the business is willing to take on. So we do that searching at the preliminary level to see what's registered. Let's just stick with the United States right now. In the United States, you also get rights just from using a mark, even if you don't have a registration. There are many benefits to registration. I'll talk a little bit about those in a bit. But you don't have to register a mark, and you get rights just through the use of the mark. That's called common law rights. Because of that, searching the trademark database doesn't give you the full picture of the risk associated with using a given mark. And so then we have to do what's called comprehensive searching. And I have a picture of a Google search here. A Google search is a good start. The problem with it is you're largely going to find exact hits. So let's say your mark is thermos. If you do a Google search for it, you're going to find what's out there using the word thermos and see if there are goods and services being used with that mark that would be a problem for you. The issue with that is there could be, that won't show up in your search, things like thermal or thermo or thermos, many different things that are similar. And if those similar marks are used in connection with similar goods and services, that could create a risk of an infringement claim against you. And so you want to be careful about that. So we use comprehensive searching, where we go to third-party search companies, and they capture all of those, not only identical, but also similar marks used for similar goods and services. And it's a fairly labor-intensive process. It takes time to go through those searches, but it's really the only way to get a good sense of the level of risk associated with any given mark. Let's go back real quick. Okay, so I'm choosing a name. I've come up with some really cute things. Should I go with those? And the answer is you have to be careful. First of all, why is it cute? Are you alluding to another brand or just an idea or something? If it's just an idea, I'm not worried about it. But if you're alluding to a brand, it can be a problem. A couple examples are up here. First of all, in the middle, Goats do Rome, catching on the Côte de Rhône aspect of things and trying to allude to that. First of all, the product is not a Côte de Rhône. It's not from the region. And so they could have an AVA problem, although the Côte de Rhône is elsewhere and it wouldn't be an AVA, it's an AOC it would be governed by. But that's an issue that's kind of outside of trademark that could be considered otherwise. But leaving that aside, Goats do Rhône doesn't make fun of any particular trademark. And so because of that, it doesn't give me any pause as far as, sorry, I'm just going to get this off the screen. It doesn't give me any pause as far as a third party taking action. On the other hand, when you allude to somebody else's brand, it's a different issue. And so a couple examples up here. First of all, Grape Nuts Wine Club, cute, right? I'm sure they're all nuts for grapes at the wine club. It does certainly call out Post's brand Grape Nuts. Now you might say, yeah, but they make cereal and Grape Nuts is a wine club, and you just said that one of the key factors is how similar are the goods. Well, there's another wrinkle to it, and that is famous marks get much broader protection. And famous marks can actually stop others from using even similar marks for even unrelated goods and services. And so, of course, the best targets when you're coming up with a cute punny name are famous marks. And so there's always a concern about that. And so then the next step people turn to is they say, well, freedom of speech, it's First Amendment. I'm parodying this other brand, and that's protected by the First Amendment. And the key here is parody versus satire. It's true that parody is protected, but in order to qualify as parody, you pretty much have to be poking fun directly at that other brand, making a statement about an issue you see with that other brand, something like that. Satire, on the other hand, uses somebody else's product to say something funny about something unrelated to that product. So with here, Grape Nuts does not make fun of Post or tell you anything about Post. It uses it because it's cute. And, you know, I don't represent Post. I don't think Post cares about it, but if they did care about it, they could certainly have a strong argument that this is an infringement of their rights. On the left, similarly, we have Jack Daniel's, very famous whiskey brand, and Bad Spaniels for dog toys. This went to the Supreme Court, and the Supreme Court at the end of the day said, no, Bad Spaniels, you're not making fun of Jack Daniel's, you're merely using their brand for your purposes. It's cute, it's fun, but it's somebody else's property. And if you want to do that, you need to get licensing from them. And they didn't, and so they lost that, and I'm sure it will settle in some form, but the lawsuit continues at lower courts. But the bottom line is Bad Spaniels is going to have to either change their brand or get license from Jack Daniel's. All right, so registration. There are a couple of different levels of registration. The first, and the one that's best to pursue as a US company, is federal registration. A couple of reasons. It gives you constructive nationwide use. So trademarks are territorial. Your rights in them are very territorial. So if you're relying, for example, on the common law rights, those rights that just arise when you use a mark, those will be limited to where you have sold your product. Where is your product available? And so that can be a very limited geographic area. If you get a federal registration, you get constructive nationwide use. So suddenly your rights cover the entire country, which is obviously very valuable. If there's somebody in Texas that's, why do I keep picking on Texas? Why not? So if there's somebody in Texas that's causing a problem, your federal registration will give you rights against them. As always, there's a caveat. And the caveat is that your rights are nationwide, but you can only enforce them when and where you get to that geographic area. So if there's somebody in Texas that's infringing my rights and they started after I registered my mark, and so I know I'm the senior user and I have rights against them, I can't sue them based on my federal registration until I start offering product in Texas or geographically where they are. So this happens a lot, especially with wine companies that are just starting, that know they're going to have nationwide distribution. We get the registration. Then when somebody in some other place is using a mark that's a problem, we write them and we say, hey, we have a federal registration for this. We will be in Texas within, a certain period of time. And we will be knocking on your door at that point. So it'd be best to figure things out now before you spend a lot of money and time on this brand that you're not going to be able to use shortly. And a question comes up often, what about online? Am I not using nationwide the minute I have a product available? And the answer is, if it's actually available in other states, then absolutely, that is use in those other states, and that would give you use and rights and the ability to enforce your trademark registration in those places. The question is, can you show that you could supply the product at the time you're saying you have those rights? So it's one thing if you have, for example, you're online and it can be accessed by anybody in the country, but you can only deliver to California, Oregon, and Washington because of your distribution agreement or something like that, or laws that are in place. If that's the case, then your registration is only going to give you protection in those places where you can distribute the product, even though anybody in the country can see your product online. So if you don't get a federal registration, well, first of all, why might you not get a federal registration? The first answer is because you don't have use in interstate commerce. Now with wine brands, you almost always have use in interstate commerce because of the way the alcohol laws work, and the fact that there are not just state rights, but federal alcohol issues as well. And so it's very quick to get and easy to get that use in interstate commerce with wine, but not with all goods. And so if you're not shipping your products to more than one state, then you may not have use in interstate commerce, and you may not therefore be able to avail yourself of a federal registration. In that case, you can still get protection. You can get a state registration here in California. That state registration is similar to a federal registration, going to give you strong rights. It's just going to limit those rights to the state of California. So you'll only be able to stop others from using the mark who are in the state of California. And then what about international registration? International registration has to be pursued country by country. It gets very expensive, but it can be very worthwhile when you're shipping your products around the world. There is what's called a Madrid Protocol application, and that basically takes your US registration and enables you to extend that registration to most countries around the world. And it's well worth it. It's well worth it in the wine industry. I argue against it in many situations for many clients, especially my tech clients. And the reason for that is twofold. First of all, under the Madrid Protocol, you can only apply in those other countries for the goods and services identified in your application. And in that case, the USPTO is very specific about what they want your goods and services identification to say, and with very complicated tech products, it can be very limiting. Whereas other countries and jurisdictions, the EU, for example, you can get a much broader description of your goods, which gives you much broader protection. And so therefore, the Madrid Protocol is very limiting. Not so limiting when your goods and services are wine. You're not going to probably change that very much, or alcoholic beverages other than beer. That's pretty standard description worldwide, so you don't lose much by using the Madrid Protocol application there. The other issue with the Madrid Protocol application is if you extend to all these countries around the world and somebody decides they don't, they're going to take issue with you and they're going to fight back against you, they may well attack your US registration. Because if they attack your US registration and they succeed, all of your other registrations around the world that are based on that US registration can then be taken down. And so it's what's called central attack. And when you use the Madrid Protocol, your registrations around the world are subject to central attack. So when do I worry about that? I worry about that when we're using a mark that searching shows, there's a lot of close stuff out here. We could have some arguments about this. And if somebody can attack you with a central attack, they're going to have a lot more leverage in any negotiation they have with you because you have a lot more on the line. Whereas if I register individually in every country and don't base it on the Madrid Protocol, they would have to oppose me or take action against me in every country separately. And so it's going to be a lot harder for them. So I consider the Madrid Protocol on a case-by-case basis. It's more common for me to be willing to recommend it to clients in the wine industry than in other industries, say the tech industry, but it's still not necessarily the best way to go, and it has to be considered on a case-by-case basis. If you do get a registration, you get to use the Circle R. Not that big a deal in the wine industry. It's more in consumer products areas, commodities that people want to use the circle R. Wine labels, probably not the prettiest thing on your label. You're not required to use the notice just because you got a registration, so it's really up to you. So the notice isn't the biggest deal to most of my wine clients. And then the last thing is cost. Trademark registration used to be relatively inexpensive. I used to quote $2,000 to $3,000 from start to finish for a registration. That has probably nearly tripled on average. And the real reason for that is that there are, well, twofold. First of all, there are so many more companies seeking trademark registrations now that it's very difficult to find a clean mark where we don't see a moderate level of risk that we're going to run into objections from third parties or from the PTO itself. So I have to argue with the PTO a lot more than I used to in the past, and that drives up price. And then there's always the risk of third parties raising issues, and that can drive up price. The second issue, again, not so much in the wine industry, but the PTO has become very draconian about how they want you to describe your goods and services. Again, it's easy with wine. You can call it wine, you can call it alcohol beverages other than beer. Very straightforward. But again, in the tech industry or with products from wineries that are more specific, it gets more difficult, and it leads to, again, an argument back and forth with the PTO about what they're willing to accept. So, again, I used to say $2,000 to $3,000. I would probably say, $6,000 to $8,000 now for a registration from start to finish. So infringement claims. What if somebody out there is using a mark that you say is just too similar to yours? What can you do? Well, you can sue them for trademark infringement. First, you have to prove up that you have rights. So the easiest way to prove up those rights is by having a registration. All you have to do is file that registration, and the court will say, yes, you have rights. Now, the other side can attack that registration, but it's proven up by you as an initial matter just by putting in that registration. Now, if you don't have a registration, you're going to rely on common law rights. You're going to have to prove up those common law rights. So you're going to have to put in evidence that shows where you've sold the mark, when you started selling the mark, selling the products, all of those kind of things. So you can prove up those common law rights, but it's obviously a lot easier if all you have to do is file your registration with the court. Infringement claims are very expensive, and it's important to note that in the US, there's no fee shifting. I shouldn't say that. There's limited fee shifting. If you can show that somebody was basically specifically trying to rip you off, counterfeiting, those kind of situations, there is fee shifting. But if it's just a question of, is this mark too close to yours? And there's, reasonable minds can differ on that, but you might win. But in that case, you're not going to get your fees back. And so, if a case goes to trial, you can be looking at $500,000 or more. If that's a sunk cost, it definitely affects whether you're willing to litigate at the end of the day or not. Moreover, damages are really hard to recover. If you get a slam dunk, again, it's much easier, but at the end of the day, if you win an infringement action, you're going to have to prove up damages, and that's not always easy. So what I tend to find is companies that do sue are just looking to get that injunction to stop the other side from using that mark that they felt was too similar. And where this really plays out is in settlement. Because if you go into settlement negotiations thinking you're going to get a big payout from another company, it's unlikely you're going to get anywhere because everybody knows damages are difficult to recover. And so they tend not to be a big part of settlements. And instead, it's really, you're looking to push somebody off of using that mark. And that's usually where we push settlement negotiations to.
If you send the notice but then don't litigate it, do you risk losing the trademark for lack of enforcement?
Great question. So just to make sure everybody heard, the question was whether if you send a demand of some kind to somebody else, but then you don't take action against them, do you lose the rights? Or are you at risk of losing the rights? And the answer is yes, you are at risk, but it doesn't mean you will lose the rights. What it tends to do is a couple of things. First of all, if you don't take action, you have a letter out there that says you think that other mark is similar to yours, and you didn't take action against a mark that's similar to yours. So that cuts into the strength of your mark. Because if you said there's other things out there that are similar, that I'm not stopping, then maybe my mark doesn't identify one source anymore. Other thing is that information tends to get noticed by others, and people get more brazen. Oh, they didn't take action against Joe, they won't take action against me. And so they put that into their calculus when choosing marks. But there's nothing that, suddenly your mark disappears or your registration disappears. Now, if you file an infringement action against somebody, or if you send a demand letter to somebody, they could file an action to cancel your trademark. And that's a risk you have to consider. You have to consider are there some bases that they might have to take action against our mark. So it's a great question because it's exactly the kind of thing you need to be thinking about before you whip off a demand letter. It really has to be taken very seriously. I have a lot of clients saying, well, we'll never sue, but let's send them a letter. And I caution against that strongly. It just really puts you in a difficult position. The other thing to consider with that, not for nothing, but you send off a letter to somebody and say, stop using that mark. They're in Texas. They say, not only am I not going to stop using this mark, I'm going to file a lawsuit against you in Texas to have a judge tell you that my mark is fine. It's called a declaratory relief action. And suddenly that case you thought you were going to not undertake at all, or at worst, undertake in San Francisco, is suddenly in Texas. And you have no choice but to defend that, because if you don't defend it, you lose. And that's when it really does cut into your rights, because then you've got a judgment on the books saying that your mark is not similar to this mark that you feel is very close to your own. So a little long-winded, but some issues to think about with infringement claims. As with registrations, you have to sue in individual countries. So if somebody's using a mark in France that you feel is too close to your mark and you're selling in France, you can't just sue here, you've got to sue in French. A couple of additional tools to think about though, and we use these a lot, are oppositions and cancellations. These are against registrations, not against somebody's use. But if somebody can't get a registration, they're less likely to use a mark. And very often we keep watches on behalf of our clients for similar marks that are out there that are applied for at the USPTO. And if we feel they're too similar, we can take action at the PTO level through the opposition process. Cancellation is for when a mark is already registered and we think it's a problem, but we just found out about it. We can sue to cancel that. Or if it is an application, we can oppose registration. Tends to be cheaper, a lot cheaper. And again, it doesn't affect use, but if somebody doesn't get the registration, that may be enough to keep you comfortable that, yeah, it's not so similar that I'm worried about them using it somewhere. I just don't want them on the register with me at the USPTO. And so it can be worthwhile, and again, much cheaper. So that's it for trademark right now. Obviously, there's a million other things I could talk about, and happy to discuss anything if anybody has any questions, but I'll move on to copyright. So as we talked about, trademark protects the brand or the identifier of the source. Copyright protects original works of authorship, those creative works. And the actual line from the copyright, from the Constitution is that copyright protects original works of authorship fixed in a medium of tangible expression. So original works of authorship, pretty clear what that means. Medium of tangible expression just means it has to be fixed. It can't be, classic example is smoke signals. Smoke signals cannot be, you cannot register a copyright in smoke signals, bless you, bless you. And in fact, it's difficult to register a copyright in any kind of performance. Instead, what you're registering is either the notation of the performance, the description, for example, the score, that would be very registrable, or the recording itself, that can be registered. But registering a performance that is not recorded, is not written down, can't protect. Some examples of things that are eligible for protection, the things you're used to. I don't think anything here would shock you, but do note that when I talk about dramatic works, pantomimes, choreographic works, it has to be fixed in some way. It can't just be the performance itself without recording or without any kind of notation. So what's not eligible? Things that aren't fixed, and then ideas. So the idea example I like to use is James Bond. James Bond is a character that's very protectable. The aspects of James Bond, I'm sure everybody has an image of their mind and, words come to mind, but the idea of a spy can't protect that. Anybody can write a book about a spy and will not infringe anybody else's rights. What about a British spy? Probably still fine. British spy is not a unique thing, can't be protected, isn't specific enough, isn't fixed enough. What about a British spy who is, kind of I don't know the right word to use, but Lothario. Still, that's getting a little more specific, a little more unique, but probably not protectable. What about all of those things and he drinks martinis? Getting there. How about martinis that are shaken, not stirred? Yeah, you're probably there. If somebody else writes a book and makes it about a spy who is British, who is somewhat of a Lothario, who drinks martinis, shaken, not stirred, I think they would have Ian Fleming's estate would have an action against them. So you can see how it's a continuum. And when do you hit the idea versus expression? When do you get over into expression? Great question. Wish I had the answer every time, but it's a very gray area, and that's where the litigation comes up. So what do you get when you own a copyright? And first of all, much like a trademark, copyright doesn't have to be registered. You get rights in a copyright the minute you do it, the minute you create that thing, the minute you fix it in a medium of tangible expression. But what do you get? You get a bundle of rights. You get the right to copy, display, create derivative works from, and perform that work. So most classic example for a winery would be your website. Your website is very protectable under copyright, and nobody can just take chunks of your website and use it for their own. That's your right because you own the copyright. I see a lot of times, I see the word use. I see it in licenses. I hereby license you the right to use my work. Or the word use is not in the Copyright Act, not in the Constitution. It's not one of the rights you get under copyright. So what I tell clients is if we're licensing to somebody else, I won't use the word use because who knows what it means? I don't know what it means. The law doesn't say what it means. Let's not use the word use. But if I'm getting a license from somebody, I love to put in the word use because who knows what it means? And if you do something that they don't like, we can always point to, you said I could use it. And so I like it as broad as possible in that sense. So it is a word to keep an eye on. And who's the owner of a copyright? This is actually really important for all of us out there. It's the author. The author of the work owns the copyright. There are two exceptions to that. And that's where a work is a work made for hire. There are two forms of a work made for hire. The first is anything created by an employee in the scope of their employment is a work made for hire. So if you have a marketing person at your winery and it's part of their duties to create website content for you, all of that content is owned by the winery. But if that employee is actually your winemaker and they say, yeah, I'll help out, I will create some content for the website, there it's a little questionable whether that employee is acting within the scope of their employment and whether the company or the employee is the owner of that work, of that website content that they create. So you have to be careful there. In most cases, it's not a big deal. When does it become a big deal? When the person leaves and the person isn't happy. If the person wants to seek revenge, in one way or another and just make things difficult, that gives them a hook. So you have to be careful about what employees are creating works for you if you want to own and control those works. The other situation is where you have an independent contractor. Where you have an independent contractor, it can be a work made for hire such that the employee owns it. But we'll talk about it in a minute. You have to be very careful with that. And I'll explain why. The third situation is where you can be an owner, but you're not the author, and that's by being an assignee. And in many cases, that's the best result is to get the assignment from the person who created the work. So I went over this a little bit, and as I said, work created by an independent contractor can be a work made for hire, where it's commissioned and agreed to in writing, and the writing has to say that it's a work made for hire, but it's in very limited circumstances. The place that this was created for was really in connection with audio video. You know, when you make a movie, for example, the company doesn't employ full-time, well, it doesn't have as employees all of those individuals that do the work on the movie. Those are, you know, industry people that they hire in to work on the movie every time. And so they're all independent contractors. And basically the movie industry lobbied and said, we've got to own all this, you know, it's our movie. And so they made it easy. They said, okay, just put work made for hire in your agreement and you'll own it. And that's really what it's for. And the Copyright Act lays out the specific types of works that qualify for this work made for hire idea. And it's not every situation. It's a very limited set of situations. So what I get a lot though is, well, it might not be my situation, but I'm still going to say it because at worst I get it. You know, I'm held as the owner, and that's better than being an assignee. And I'll talk about that in a minute. But they do want to be the author rather than an assignee, and they say, so we'll put in this work made for hire language. The problem with that is there's a California Unemployment Insurance Code section 686, if you're interested, that says if you use work made for hire language in your independent contractor agreement, that independent contractor is no longer an independent contractor, they are an employee. And so that can have lots of, I'm not an employment lawyer, but I'm told that can be very problematic. And so you really want to avoid that work made for hire language. And instead, when you have independent contractors, you want to hire them using your independent contractor agreement, and in there get an assignment of everything they create rather than claiming that it's a work made for hire. So why not just have the assignment? Why is the work made for hire better? The Copyright Act provides for termination of assignments between the 35th and 36th year after the creation of that work. And so, you know, seems like not a big deal in most cases, and in most cases it's not. I mean, your website content, I'm going to venture to guess, is not going to be there in 35 to 36 years. You're going to have very different content. But imagine for a second music, you know, recordings. All of these master recordings, we hear about it quite regularly now, that people are filing to terminate their assignment to their record companies so that they can now distribute their music instead of relying on that record company to do so. And, you know, music is long lasting, as we've seen. So in some situations, the assignment is not as good as being labeled as a work made for hire, but for all intents and purposes, for our purposes, I think it's usually fine. And in fact, it's the only option because most things don't qualify as a work made for hire. Copyright registration is really cheap. It's like the fee is $45. You send in a deposit copy. It's pretty straightforward. It's best to have that registration sooner rather than later, because in order to sue, if somebody steals my photograph, let's say I have a great photograph on my website and they use it for their own line and it's on their website, in order to take action under the copyright law, I have to have an actual registration. Registration takes a couple months to get. I could get it in a number of days, but then I have to pay a huge extra fee in order to get it. So you really want these. If you're going to file copyright registrations, just do it as a matter of course. It's cheap and easy. The other thing about it is, if you had the registration prior to the infringement starting, you do have fee shifting available to you, and you do have the right to be awarded statutory damages. So you don't have to prove up damages, which, as I said, with trademark can be very hard. So getting a copyright registration for photographs, for your website, anything you tend to put out there in public is worthwhile. I have a lot of clients who just set it up they do it on a quarterly basis. They re-register their website content on a quarterly basis. They know it doesn't catch everything, but it catches most things.
Is that like you print screen and you just like get a really large or PDF and that's just like you submit that, or
That's
you
exactly
submit
it.
the URL, or
No, that's exactly right. You print out the website and you send it in as the deposit copy. You know, I have a lot of clients that actually have a lot of photographs, and they tend to do those in batches. They don't register each photograph separately. They do them on sheets, you know, of, I would say I talk to them about, you know, about 50 is what I think is okay to put on a sheet. But, you know, at $45 a pop, it's not that big a deal. But when you're talking about thousands of them, it can get expensive, no question. I think I talked about most things here. The key is that registration, having that in place. So that's infringement. The area that we need to be concerned about it a little bit, that's a little unique, is first of all, software. Now most software comes through subscriptions, so it's not a concern anymore. It used to be that we used to get hard copies, you know, of software and load them onto the system. In that case, you have to make sure you have enough seat licenses. That is, that license of that software is going to be for a certain number of people to use. Well, back in the day, and still in many places, you can put that disk in anybody's computer, or that file, you know, you can upload that software to anybody's computer. And if that's the case, and you are using more copies of it than you are licensed, you could be infringing the software company's rights. So you have to be very careful about that. The other area it comes up is with user-generated content. So a lot of sites allow users to post things about you or about their experience at your winery, that kind of thing. And sometimes they can do pictures, which is great. You want your customers engaging with you. The problem with it is if they didn't take that picture, but instead stole it from somewhere, you know, just cut and pasted it from a website somewhere and put it on your site, you can be liable for that. And so you have to be careful with it. So what do you want to do to avoid infringement claims? First of all, get those assignments when necessary, licenses when you need them. So if you're going to use somebody else's work, go ahead and get the license. You can rely on what's called fair use. You can say, hey, I'm allowed to use your copyrighted image or copyrighted work. But you have to be really careful with that. It's much rarer than people think it is. And you just have to be careful before you think you're just going to say, you know, I get to use this despite your rights in it. Other safe thing to do is get things in the public domain. When I have pictures in my presentations, they all come from places where either we have a license or they are public domain images. What's the public domain? The public domain are things that nobody can claim copyright in. So first of all, things created prior to, I never keep up with the year, but I think it's about 1928 now. Anything before 1928 is in the public domain. That's why I can, you know, quote Shakespeare anywhere I want. I could put a whole Shakespeare play in here and nobody would have an action against me because it's in the public domain. The other way things end up in the public domain is they're granted to the public domain. That is, people say, I claim no copyright in this, and they place it in the public domain. And then there's the DMCA, and this is an important thing. We're going to talk about website terms of use at some point, but if you're allowing people to post things on your website, the DMCA is a law that gives you the ability to avoid infringement for user-generated content posted on your site if you check a couple of boxes. You have to have a policy on your site. It's called a takedown policy. And if somebody writes you and says, hey, this user-generated content on your site is infringing my rights, you have to take it down. There's a process that you go through, but the DMCA gives a lot of protection in that user-generated content area. Copyright notice, this is the Circle C. It's not required in the US, but there are benefits to it. I would say the benefits are, you know, more psychological than anybody. If somebody sees a copyright notice, maybe they'll be less likely to steal from you. But the actual benefit or the technical benefit of it is they can't claim that they're an innocent infringer, that they didn't know you claimed rights in it. It's very difficult to be an innocent infringer. So yes, it gives you a benefit to use the Circle C, but it's a very small benefit. What about, we see this all the time, all rights reserved. That used to be an issue. There was a treaty in place and certain countries required all rights reserved. And so we used it in the US as well. That's all gone. We don't need to use all rights reserved, but it's become such a part of the expected verbiage that's used that if it's not there, some people might think, oh, they're not claiming the whole copyright. They're only claiming, this little bit or something. So kind of the general way things go, I do recommend just using it. So how does your copyright notice appear? And it would only need to appear once on your website, but the circle C, the year or years that the works showing up there were created, and then the claimant's name, followed by all rights reserved. Pretty straightforward. Definitely worth it to put on your site, whether you register anything or not. Go ahead and put the copyright notice on. Really quickly, AI is everywhere. Just a couple things about AI and copyright. You can't own copyright in AI generated content. That image on the left was created by AI, and the owner of the system that created it tried to register it, and the Copyright Office said no, human authors only. You cannot have a copyright in a machine created work. It gets gray though, because it's one thing if I say, paint me a picture with train tracks going through a tunnel, and the AI does that. What if I say, paint me a picture of train tracks going through a tunnel, put purple flowers around, each side? How much involvement does the human have? And that's what the courts are working on now, is to determine when is it that you've crossed that line from machine expression to human expression. So we'll see, stay tuned. Now note that AI generated content can infringe third-party rights in two ways. The first question is, you've heard of these large language models like ChatGPT that get trained by using information that's on the internet. Well, they're reading all sorts of things, and they read lots of copyright protected things. When they read them, they actually download copies of them. And so they are copying those things, and they are making copies of those things, which is one of those protected rights. Question is whether that's infringement. I talked about fair use a little bit ago. Probably going to turn out that those uses are fair uses because they're not using them for the same thing that the original was there for. They're using them for what's called a transformative purpose. So at the end of the day, that's probably not going to be a problem. The other way AI generated content can infringe is when it sees something and you ask it to make a picture and it makes something similar to something that's already out there. This is a case currently being litigated. The picture on the right is a Getty Images picture that is theirs. They own the rights in it. And the picture on the right was AI created. Somebody said, create me a picture of, soccer players, sorry, football players, something to that effect. And it created that. You and I could discuss whether it's similar to the other or how similar it is, or whether it knew about the other one, et cetera, or whether it copied it. But that's being litigated right now. And obviously Getty thinks that it is an infringement of its copyright. Talk about trade secrets really quickly. Check on my time here. Oh, I'm a little late, so I'm going to buzz through some things because I've taken too long. So trade secrets have to be secret, and you have to take action to prevent their disclosure. So use NDAs. If you're going to disclose company information to somebody, use confidentiality provisions. Make sure that you're only giving it to people that have a limited right to know and a duty to keep things secret. So what might you have? You might have recipes. You might have processes that you use that you want to keep secret. You might have customer lists. 3 quick examples of trade secrets you want to protect. If you want to share those with anybody, say you want to share it with one of the email companies, can't think of what they're called right now, but the ones that send out emails on your behalf to your customer base. When you enter that contract with them, you have to make sure that your confidential information, including that customer list, is protected, that they can't use it for anything else and they can't share it with anybody. Agreements, we talked a little bit about the website terms of use. I just want to quickly say, when you're getting people to sign up on your website and you want them to be subject to your terms of use click wrap. Don't simply say, have something at the bottom that says, by using this site, you agree to our terms of use. That's not going to get you very far if you want to enforce those terms of use. You need them to click a button. Usually it's when they sign up to be members or something like that. And you need a box that says, by agreeing to this, I agree, by clicking this box, I agree to these terms of use. And the terms of use are linked right there, and it's very clear that it's a link. That will give you enforcement ability with those terms of use over the individual. You just have to be very clear. The courts don't like hiding the ball. Bunch of key terms to have in there. I'm just going to go past this stuff quickly. Privacy, I'm going to be really quick about. There was a time when privacy seemed like a joke, but the bottom line is that it is here to stay. It's a big deal that we're dealing with. Key is you need to have a privacy policy. Whether you're subject to the CCPA, which we'll talk about really quickly in a minute or not, you need to have a privacy policy in place on your website so that people know what you're doing with their personal information. The key current laws, here it's the CCPA, in Europe it's the GDPR. Come back to that. There are a lot of other state laws, but really if you're complying with the CCPA, it's kind of the lowest common denominator. You're largely complying with the other state laws, so it's less of a concern. I get the question a lot, do I have to comply with the GDPR? The answer is probably not. If you have assets in the EU, you probably do. If you have significant business relationships in the EU that have contractual relationships and those contracts call for you to comply with the GDPR, well, then certainly you need to do so to not breach those contracts. And do you have any plans for future deals with EU entities that are going to be interested in what you've done with personal information? But generally, the GDPR is simply not going to be enforced against a California company. The CCPA, however, which is the California law, will be. It applies to any company in California that has, well, it applies to any company that has gross revenues greater than or equal to 25 million in the previous year, or that buys, sells, shares, or collects, just has the information of at least 100,000 California residents, household, or devices. That's a pretty low number. Mailing lists get to that level very quickly. The third, which is not anybody here, are they get at least 50% of their revenue from selling personal information. The bottom line is the CCPA very likely applies, and even if it doesn't, people expect certain rights that you might consider. Personal information is anything that identifies a person, pretty straightforward. Your privacy should, and this is CCPA or otherwise, disclose what you're collecting, why you're collecting it, and who you're sharing it with. That's really what the privacy policy is about. It's important to have one if you're collecting personal information from anybody. Remember, an email address is personal information. So the minute you collect emails, you should have a privacy policy. More stuff, just opt in and opt out. When you want to send somebody email in the US, you don't have to get them to opt in. It's a nice thing. In most countries, you do have to get them to opt in. But if they opt out, you need to respect that opt out. So if they tell you don't send me emails, don't send them emails. Some quick privacy takeaways, and this finishes it up for me. I think the best thing is to, or the most important thing is to really understand what you're collecting. I've talked to many clients who I talk to the IT department, well, I talk to the marketing department and they tell me I'm collecting X, Y, and Z. And then I talk to the IT department and they say, oh no, we get much more information than that. And so you really need to understand what you're collecting so that you can disclose properly in your privacy policy. So with that, and sorry to rush through at the end, but I do want to try to not take too much extra of people's time. I really appreciate it. And if anybody has any questions, I'm happy to answer them. And you can always find me by email or phone.